Hi, everybody. Lucia Valenzuela here. I have with me today Karima from Innovent Law. Karima is an amazing patent and trademark attorney. And Karima and I started talking about the work that we do in the crossover. And what I find in my work is that a lot of my clients are claiming R&D tax credits, but they don't have a patent assigned to it. So I got to thinking maybe it would be fun to give everybody information on how to file a patent. And maybe, just maybe, there's an inventor out there who's thinking about a product and wants to know what the next steps are. So thank you so much, Karima, for agreeing to do this. And yeah, tell us a little bit about what you do.
Thank you, Lucia, for having me. As you mentioned, I am a patent and trademark attorney. This is my second career, so I was an engineer for about 8 years before switching over. So I love working with inventors, people who are in R&D, phases in development or inventing, and get to sit down, brainstorm with them, help them protect their work, help them get the broadest protection possible on their work as well. So I'm really happy to be here.
Everybody's dying to know, what's the first step that you have to take to file a patent?
Sure. So a couple of things. A lot of times I get asked whether you need an actual working prototype to file a patent. And no, you don't. So patent is really the idea and the reduction to practice, what we call reduction to practice. So the idea for the invention. And two, either the reduction to practice is the actual prototype, or if you don't have that, enough notes and drawings and things like that to enable someone to make it. So as long as you have that idea and enough details, drawings, and notes to have someone who is skilled in the art make that, then you have enough for filing a patent.
And how do you determine if your idea is patentable?
So there's typically here a couple of scenarios. One, I almost always recommend doing a patent search. This is a long and expensive process, and you don't want to go into it just without knowing what the landscape looks like for your invention, for your industry. So I always recommend starting with a patent search, getting to see what sort of potential rejections you might get. And it really helps us draft a better patent in general. Just knowing what sorts of rejection we're going to be getting allows us to draft a stronger patent. The one time where I typically don't require or ask for patent searches is when it's a well-established business within the industry. They already have a lot of, they have a big IP portfolio and patent portfolio, so they know the ins and outs of that art unit or that industry. In general, it's highly recommended to start with a patent search.
I've heard, I'm not an expert in this and I don't know if I even know what I'm talking about, but I've heard that there are strengths and weaknesses to certain types of patents. Can you tell us a little bit about what the strongest patent would be that you'd be assigned or given, and maybe what some of the weaker patents are?
Sure. So there are typically three types of patents. You have a utility patent, and that will cover the functionality of something, the way it works. Then you have a design patent, and that one covers the ornamental features, so the outer design of that invention. The third type of patents, and that's a less common one, is a plant patent. So any new plant that you come up with that is asexually reproduced can get a plant patent. But that's a very niche area. So the two main types of patents that you'll see all the time are, one, a utility patent, and two, that design patent. So the example that I like to give, mostly because I always have a Sharpie or a pen handy, is I came up with this idea for this Sharpie or for this pen, and I want to protect it. So I can protect it two ways. One, I can protect the functionality of it. So for example, I have a tip and there's an ink cartridge in here. When I press my pen down on a piece of paper, the ink starts flowing, but it's not smudging everywhere. And I want to protect that functionality. Or for example, my tip is, providing ink evenly, and I want to protect that. So that would be the functionality of it, and you would be covering that with a utility patent. On the other hand, if this is a new design for a pen, or for example, this cap is really cool and it has, two portions in here and it has like a third thing in there where you can clip it, and I want to protect the design for that, then I would use a design patent. Design patents really are the drawings. The drawings, what you submit and what you end up with on those drawings are really what you're protecting, whereas the utility, you're looking at the claims, and it's a set of language that will cover, that will typically give you a broader protection.
So the utility patent is a stronger patent than the design patent.
It's a broader one, and sometimes inventors or businesses will use various types of patents in order for them to create a strong portfolio. So for example, in the pen example that I was giving, if I want to cover both the functionality of it and the design of it, then I would be using both. But in general, the utility will give you broadest protection.
And if your patent application is rejected, and I heard you use that word before, can you modify and reapply, or what are the substantial changes that you have to make in order to get approved?
Sure, and I'll talk about mostly the utility patent because design patents in general are a lot easier to obtain. You submit a set of drawings and you either get some objections. If you get a rejection on a design patent, you can still, file with different images or different drawings. But for the utility one, all utility applications will publish within 18 months, so they become automatically public unless you file a request for non-publication. But other than that, you can essentially be prior art against yourself, which is why you should never try to do this on your own without the help of a patent attorney. But so we file our application, and then we typically get the first, what we call office action. And that one can have either objections or rejections. And it's normal to get that, at least that one first office action for utility patents. And then at that time, we can basically amend the claims, make them narrower, add certain features from our background and from what we've already submitted to try to narrow the scope and get that application through. You can't add anything new. So once you're ready to file a non-provisional application and you're getting that rejection, you can only amend it for what you have support for. So for example, I filed for our pen, right? And then I have, for example, a cap, like a cap at the end of the pen. And I submitted that in my original application. I'm getting a rejection because somebody has done everything in there, but nobody has ever thought about the cap. Now people are going around with a leaking pen in their pockets. I came up with the cap idea on top of everything else. I'm getting a rejection. I can introduce the cap back into the application, narrow that scope of my application, but at the same time, I'm not adding anything new. This was already something that I had in the background of the application that I submitted.
I see. What would you say the timeline is for you to file a utility patent? Let's just take your pen example. What would be the average timeline that it would take to prepare the application and then also to file and hear back?
So great question. There are some statutory bars for patents. So from the time you actually disclose your idea to the public and the time you put this on sale, you have 12 months from that time. So for example, I started telling people about my pen November 1st, 2020, or I started selling it November 1st, 2020. I have until November 1st, 2021 to go and file a patent and get a patent on this. After that, you are barred technically from getting a patent on that invention.
So for my inventors, or the folks that are claiming R&D credits on items that are already in production, they cannot go back and claim a patent for that item that's already in production. Is that what I'm hearing?
Production, not necessarily, unless they've already, so for example, if they're producing it but have not started shipping yet, have not started selling yet, have not started telling other people or the public or marketed for it yet, then it's okay. But the minute you start marketing it, telling people about it, and you have that 1 year. What you can do is get a patent on any improvements that were made after that 1 year, but anything that was disclosed for those 12 months is basically not something that you can get a patent for.
What about cost? I think folks are hesitant sometimes to go after patents because they think it's going to cost a lot of money, or they've heard horror stories of it costing millions of dollars. And I know some of these companies with big patent portfolios do often spend millions of dollars on their patents, but on average for a utility patent for a new inventor, what is the cost range?
Sure, and I hear that confusion all the time when I give the quote and people are like, oh wait, so it's not hundreds of thousands? I'm like, no, it's not hundreds of thousands, not for a patent or for a utility patent. So for a utility patent application, assuming we're doing the searches in general vary depending on complexity from 1,500 to 3,000 for the search, for the patent search. Now for the non-provisional, you're looking at anywhere from $6,000 to $10,000 or $12,000. A lot of firms won't include office action responses in that. So assuming 1 to 2 rejections from the USPTO, you're looking at another $1,500 to almost $3,000 or $4,000 for the office action responses or rejections. Then you have an issue fee. So what I'm talking about are just the legal fees, not including the USPTO or government filing fees. Government filing fees for a non-provisional patent application, assuming a small entity, so a small company that has not that has made a little over $189,000 the previous year, you're looking at $760 for the patent filing fees. Then there is an issue fee. So before your patent issues, you have to pay another issue fee, which is around $600. And you have maintenance fees for utility patent applications, which are, or utility patents, which are due at the 3rd year, 7.5, and 11.5 years.
Wow.
And those range between $1,000 to $4,000.
So it costs money to claim your patent and then also to keep your patent. I had no idea. That's so interesting.
Yes. Design patents are a lot cheaper. On average, you can get a design patent for $2,000 to $3,000, including drawings and government filing fees, and those don't have any maintenance fees.
Oh, awesome. Okay, well, that's great to know. Can you share any of your recent success stories with inventors that have filed for patents successfully?
Sure. And one of my favorites, so I like to say that it's a business decision at the end of the day, getting a patent. So what you're getting is really that protection, that competitive edge in the market. But at the same time, you can stop others from making and selling this. And you can also have that power of licensing this. And so some of my favorite examples are when my inventors start making money in their sleep by just licensing their patents. So one of my recent examples, someone I actually went to undergrad for aerospace engineering, he pursued the dream, started the startup in aerospace, doing rockets, nano rockets and satellites, and patented his work, and one of the big aerospace companies licensed some of his technology.
Wow.
So he's continuing to make that, but at the same time, so not only is he having that competitive edge in the market, but also generating some income from licensing part of his portfolio to other companies.
What is the youngest inventor or the youngest person that you've worked with for filing a patent?
I've worked with people as young as 12, 13 years old coming up with, either toys or software. It's really, really impressive.
So is there anything else that we should know if we start going down the road of potentially trying to pursue a patent?
Ultimately, keep those dates in mind. So that 1 year statutory bar is very important. I understand that it's a very, very delicate balance. You don't want to be spending the money before you start making it, but there are ways to protect yourself. So for example, if it's a utility application, instead of going for a non-provisional, maybe look into getting a provisional patent application, which is cheaper, but gets you a filing date, and you have 12 months from that date of filing to further, do some more market research and further development and stabilizing your invention before going and filing a non-provisional. So just a few things to keep in mind. And as always, it is a business decision. I watched on Shark Tank someone who spent over $750,000 on international patents without having made a single sale anywhere. That doesn't sit right with me because it's not the way I like to do business, but to each their own.
Yeah. If clients want to reach out to you to ask you any additional questions or get started, how can they reach you?
Sure. My email is karima@kgulick.com. So that's KARIMA @KGULICK.com. And my phone number is 949-429-0212. You can also find me on LinkedIn or Instagram as The Patent Lawyer.
Well, thank you so much for your time, Karima. You've taught us a lot, and I look forward to our next call.